On the first case, Your Honor, case number...
Mr. Cooley, are you coming up?
I'm sorry, Your Honor.
On case number 11, that would be 15 CR 255B. The state is filing an all-cross on that case, Your Honor. I may approach with that paperwork. And Your Honor, on the second case, the state is still ready for trial. We do need to file an amended accusation. I've spoken to Mr. Cooley about that. But I believe that means that we would need to rearrange it as well. We're going to have trial this week. The state's still prepared to go forward on that, and I'd let Mr. Cooley address the court regarding that. I think he has some other issues that he wanted to speak about as well.
Your Honor, first I'm going to object to the amended accusation.
Well, look, I haven't even seen an amended accusation. Is there
There
one
is, Your Honor.
already?
And I'll go ahead and file that.
Brandon Daniel? Brandon Daniel. It's just some of the wording.
And Judge, do you have
Do you
court-
have the case filed? Let me see the original accusation.
And Judge, as you can see, the only changes are with the first two counts. The statute that we're proceeding under remains the same. I added a couple words to make it compliant with that statute, Your Honor. But other than that, as far as what he's being charged with, there really is no difference. I don't know that he can object to me filing an amended accusation. We're still within our time to do so. I guess he would be entitled to a continuance if that's what he wants. But
Your Honor, I do object to the prosecution amending the wording from the original accusation, and prosecution saying I would have to be rearranged. I have been ready for trial opposite the two motions that still need to be heard. I'm prepared for trial today, and today is when the trial is supposed to take place. So I would object to any change in the accusation.
Well, from this perspective, the court would not have any authority to deny the state the opportunity to file an amended accusation. Now, whether or not there are motions that you can file or to be heard in regard to that amended accusation, I have no opinion. You obviously are free to do that. The case must be arraigned, and the state would have to, if you request it, comply with the appropriate notice provisions before you can be tried. Now, do you want the case tried on the amended accusation today? If you do, you'll waive all of your notices and proceed.
Absolutely not. I would not
Well, I'm not
waive any
going,
of my rights.
well, I'm not going to force you to do that, so I'm simply going to deny your objection to the state's right to amend the accusation and order you to respond and file such motions as are appropriate under the amended accusation. You're also given a continuance until such time as the case is called for trial after arraignment.
However, Your Honor, I would like to be heard on the pending motions today.
Well,
If Your Honor rules in my favor, then the case will be over.
what's the state's response?
Judge, we're not opposed to that. I mean, there is no, we understand that Mr. Cooley has the right to a continuance if that's what he chooses. I believe that he does desire to have the trial. We're ready for trial motions, whatever. I mean, the changes to the accusation
Well,
are very
the
minor.
only thing I would question is whether, and I haven't read any of the file other than just to look at the original accusation, whether the motions that currently are pending are appropriate to the accusation as amended, I don't know. If they are, then, I don't have any objection to going ahead and hearing them, but
The state is ready to hear those motions as well. I believe that the motions that you may be speaking about are regarding another case.
No, Your Honor, they regard
Oh,
that
okay.
case.
All right, I mean, the state is ready to hear
all right,
those.
well, we'll just have a seat and we'll call that when we get to the point where we consider. Please.
Your Honor, as we said before the break, I believe there's only two matters remaining. One of them is Mr. Burris. I spoke briefly with him. He's been trying to contact Mr. Gibson this morning. He's been unable to do so. We called him at least once again and were unable to reach him. We did receive a voicemail very early from him this morning that said that he might be by, or that he would be by later in the day, hopefully. But other than that, we haven't heard anything from him.
That's from him, meaning Mr. Gibson.
Mr. Gibson, yes, Your Honor. He left a voicemail at, what, 10 after 8? 10 after 8 this morning, saying that he had matters to attend to in Gwinnett County that we would try to make over here.
Well, he's committed, or at least he's indicated that a guilty plea, is that correct?
I believe
Yes, sir, and
that
that's
is-
still my understanding that.
Well,
when he went to the
it's
weekend.
no big deal, we'll put it on the next calendar if he doesn't appear by the time we leave today.
All right, Your Honor.
What was the announcement on Lacey Hannah?
Judge, we would ask that be continued to 11/3. I believe Lance Tyler had a conflict. I think he's in trial. And I believe filed a proof letter as well.
All right.
And that leaves us with Mr. Cooley's motions, Your Honor. And I would just let Mr. Cooley bring those before the court. I don't have anything to say at this point.
All right. Go ahead.
Good morning, Your Honor. Thank you, Cooley, for the defense.
Tell me which motions we're dealing with from your perspective, and let me find them in the file. 'Cause
Okay, the motion, which it was filed back on May 11, 2015, demand for dismissal with prejudice, violation of due process, improper arraignment.
Let me find it.
On June 9th, 2015, I had a motion hearing before Judge Booth. And this motion he reserved judgment on because he wanted both me and the prosecutor to submit case law for this motion. On June 11th, I did submit case law that was file stamped June 11th, and you should have it in the court file. It says, notice of trial court seeking case law for demand for dismissal for improper arraignment.
Well, as I understand it, in this case, the only case, as I'm aware of, that's pending, that the state has filed an amended accusation, which means that you have not yet had an arraignment. Yeah, I think the case that you objected to the arraignment on has essentially been absorbed into the refiling now. What's your response to that?
Well, if Your Honor remembers, you said I couldn't object, and also you would hear my motions before the court before I decided whether I was going to allow it to be rearranged or continue with the new arraignment for trial today. And I asked Your Honor to hear the motions because I believe that once you hear the motions, I believe the case will be dismissed.
All right, go ahead, and I'll hear you through, and then let the state respond.
Okay, this is the notice of the trial court seeking case law for demand for dismissal for improper arraignment. One, on June 9, 2015, James Real Cooley, alleged defendant, at a motions hearing in the Barrow County Superior Court before the Honorable Joseph H. Booth, having argued a demand for dismissal for improper arraignment pursuant to OCGA Section 17-16-21, right of the defendant to copy of indictment or accusation and list of witnesses prior to arraignment. Every person charged with a criminal offense shall be furnished with a copy of the indictment or accusation and on demand a list of witnesses on whose testimony the charge against the person is founded. 2, James Real Cooley, alleged defendant, argued before the trial court that the defendant was not given a copy of the accusation or list of witnesses prior to arraignment. Defendant further argued that said charges in the accusation were not read to alleged defendant in open court, and alleged defendant was not properly informed, nor was defendant asked by the trial court at arraignment if the defendant was aware and understood the charges against the alleged defendant. 3, James Rudolph Cooley, alleged defendant, did not receive a copy of said accusation until after arraignment was over in violation of OCGA 17-16-21, Georgia State Constitution, Article 1, Section 1, Paragraph 14, and the United States Constitution, the 6th Amendment. Furthermore, James Rudolph Cooley, alleged defendant, could not have, nor did he understand the nature and cause of the accusations because said accusations were not read in open court for the alleged defendant to understand. Furthermore, the trial court did not inquire of alleged defendant whether he understood the nature and cause and or charges against alleged defendant. 4, trial court at motions hearing held on June 9, 2015, requested case law be submitted before ruling on the demand for dismissal for improper arraignment. In Jones v. State, 1968, the Georgia Supreme Court quoted the Georgia Code in 1968, Section 27-1403, every person charged with an offense against the laws shall be furnished on demand previously to his arraignment with a copy of the accusation and a list of witnesses and whose testimony the charge against him is founded. 5, the Georgia Code as of 2014 removes the words on demand and is replaced with prior to arraignment so as defendants have the opportunity to review the nature and cause against said defendants as stated in the demand for dismissal for improper arraignment. James Rudolph Cooley, alleged defendant, was not given a copy of the accusation prior to arraignment, nor was James Rudolph Cooley, alleged defendant, even informed of the nature and cause against defendant. 6, trial court is responsible to ensure that defendants are afforded a fair and impartial trial, and the state cannot benefit from their own errors. 7, James Rudolph Cooley, alleged defendant, praised the honorable court, dismissed the above style action and charges against alleged defendant with prejudice. So at this time, Your Honor, I'm asking the court to dismiss these charges because I was not properly arraigned.
All right, state's response.
First of all, Judge, I believe in my file, that the document that he's referring to, filed on May 11th, I believe that's in the case that we all crossed earlier. I do see another similar filing that says motion to dismiss for failure to arraign defendant filed on June 22nd that's in this case that says pretty much the same thing. I believe that Judge Booth did ask for us to provide case law. I know Mr. Cooley provided case law. I recall researching it and think that I provided case law to him. I don't know if it's in the clerk's file or not. Frankly, Your Honor, I can't remember if he ruled on this motion or not. I know the issue is whether or not his arraignment was invalid because we handed him a copy of the accusation along with a list of witnesses immediately upon the judge basically entering a plea of not guilty for him. Mr. Cooley's issue was that we didn't hand it to him before the judge entered his not guilty plea before him. It was literally a matter of seconds. Your Honor, if I could ask the court, is the case law that I provided to the court, is that in the clerk's file? I can't remember if I stamped it in or if I gave it to the judge.
Mr. Cooley appears to be. Apparently, Judge Booth had received the state's argument because he had addressed it in a proposed finding relative to the motion. The indication being that the case law submitted basically indicated that even if the copy of the indictment and list of witnesses is delivered at arraignment, it may provide the opportunity for the defendant to seek a continuance, but not a basis upon which dismissal would be granted. Now, that's what the state's position is indicated to be.
Well, I would
It is, Your Honor.
I would oppose the state's argument, Your Honor, because if you go back and look at the trial transcripts, which I have filed a motion to receive and never been heard on that motion or received a copy of the trial transcripts, at the arraignment, the Honorable Judge Mose never did enter a plea on my behalf, nor did I enter a plea.
Well, if that's true, then your case has not been arraigned. I mean,
Judge, if I recall correctly, and we'd have to review the record of that, but I believe he has been arraigned. He did not enter a plea. The judge entered a plea of not guilty for him, basically placing this on the trial calendar. That's how we got here, Your Honor. I do have a copy of a notice of arraignment, one of his motions that has been heard. Your
All
Honor,
motions except this one.
I would argue that basically his appeal, notice of appeal, was invalid without a certificate of immediate review. But if he has anything else he needs to say, Your Honor, I leave it open for him to do so.
However, Your Honor, if this case is rearranged, I do reserve the opportunity to refile all my motions.
of course, I would think that you certainly have a right to not necessarily refile, but file motions for the appropriate period of time allowed by statute after you're arraigned. Now, that's why I wondered what we're doing here, because the case that you filed these motions on apparently is a case that has been redrawn with a new accusation. And I assume a new notice of arraignment would be submitted, and you would have the opportunity again to argue if you didn't receive a copy. And I think the new accusation was filed this morning, and I assume that the state had given you a copy.
We had, Your Honor. I mean, we provided him a copy this morning.
Well,
As I came into the courtroom and, see, Your Honor, I was prepared for trial today, pending these motions.
I kind of was expecting a trial today too, on not only this case, but several more, but apparently we're not.
I do really believe it is unfair to myself that the state wants to change things on the date of trial and now go through a new arraignment, essentially to get out of hearing basically this motion, which was for improper arraignment the last time I was arraigned.
And Your Honor, that was not the same.
I'm going to seal that immediately by addressing the motion as Judge Booth's notes indicate. That is that the remedy for the delivery of the copy of the accusation and the list of witnesses at the time of arraignment is not dismissal, but continuance, and continuance is now irrelevant because the case has been rearranged. So I'm going to deny the motion on that basis and assume that the state will properly comply with the delivery prior to arraignment on the next presentment of these charges. Now, what's your next motion, Mr. Cooley?
Your Honor, if I may approach.
You think?
Here's a copy for Your Honor. I believe the state has a copy, but here's a copy for you. Your Honor, this is an absolute discharge and acquittal. Comes now, James Rudolph Cooley, pro se by special appearance, moves this honorable court for an absolute discharge and acquittal pursuant to OCGA section 17-7-170B. If the defendant is not tried when the demand for speedy trial is made or at the next succeeding regular court term thereafter, provided that both court terms there were juries impaneled and qualified to try the defendant shall be absolutely discharged and acquitted of the offense charged in the indictment or accusation. Facts: 1, on April 8, 2014 and April 17, 2014 respectively, James was traveling in his private-owned automobile when James was stopped by Weiner police officers Wheeler and Bagwell respectively and issued citations for expired tag and license to be carried exhibited on demand. On August 15, 2015, James filed a demand for speedy trial. The August court term was in session with a jury impaneled, and the state failed to try this case at that term. In February 2015, at another court term where a jury was impaneled, the state failed to try the above-style case. The relief I'm seeking, Your Honor, is the trial court is bound by duty to declare an absolute discharge and acquittal in the above-style case pursuant to OCGA 17-7-170B.
First of all, Your Honor, if the state may.
Is that, you through, Mr. Cooley?
Yes, Your Honor.
All right.
Unless Your Honor would like to see a copy of OCGA 17-7-170B.
No, but I would like to see the a copy of the demand for speedy trial.
I do have that right here, Your Honor. There should be a copy in the court file, and this is the only copy that I have.
Well,
Judge, he sent a letter to Brad, to the DA.
let me see what you're talking about.
And I believe
Apparently,
this
several other judges are familiar with the facts of this case, but I'm not.
And Your Honor, I believe this motion has already been heard and denied.
Well, let me,
No, absolutely not, Your Honor. The reason that was sent to the district attorney was because at the time...
wait a minute, let me read what I've been handed. Okay, I've read the request for speedy trial. What, under the Georgia Constitution, what's your response?
Your Honor, first of all, he sent that before this case was ever even brought to the DA's office, I believe. I believe the case was still pending in the city of Winder in municipal court. Your Honor, we had not yet filed an accusation. We filed an accusation in April of this year. I believe this motion's already been heard and denied, Your Honor.
Your Honor, this case was in Winder Municipal Court on April 25th, 2014. At that time, it was transferred to the state, to the Superior Court, by way of a demand for a jury trial. So the state has had it since April 25th of 2014. It was the state's decision to not file this case until April of 2015. And the defendant should not bear the state's burden to try this case.
And Your Honor, that's why we're here today. This case is less than 2 years old. He's not been prejudiced in any way as far as his ability to try his case. If anything, he's been helped in his other pending cases by the time it's taken before us to reach this date. Again, Your Honor, I believe that he's already had this heard before this court and been denied this motion.
Well, let's make me the beneficiary of the history. Who ruled on the motion, and do you have a copy of the denial of the motion for acquittal on speedy trial demand?
Your Honor, I believe it was Judge Booth, and I believe it was an oral order that was given in court.
Are you aware of the history regarding the order?
Yeah, Judge, yes, Judge.
It's not part of Judge Booth's.
If I can go, I have a note of it, it's the best I can do for you. Would you like for me to go?
Yeah, if you will.
For you to reference, sure. Just 1 second.
Yeah, the law clerk is familiar with Judge Booth and Judge Moat's files on this case, so I'm gonna let him go back and.
Your Honor, the demand for dismissal for lack of a speedy trial is different than this motion, which is the absolute discharge and acquittal, which was filed on October 5th, 2015.
Well, it may be, let me get the benefit of the.
And we're not talking about the reason why Judge Booth denied the demand for the motion for lack of a speedy trial. This specifically has to do with the court terms in which if there is a jury impaneled, which it states in 17-7-170B, if the defendant is not tried when the demand for speedy trial is made or at the next succeeding regular court term thereafter, provided that at both court terms there were juries impaneled and qualified to try the defendant shall be absolutely discharged and acquitted of the offense charged in the indictment or accusation.
And Your Honor, I believe that statute would be citing a statutory demand for a speedy trial, which this does not qualify as that. It's a letter to our DA. And it was before this case was ever accused, Your Honor. All we had was a traffic ticket at this point, and we had not yet accused the case.
Your Honor, in 17-7-170A, it states in A that, and I'll read it, any defendant against whom a true bill of indictment or an accusation is filed with the clerk for an offense not affecting the defendant's life may enter a demand for speedy trial at the court term at which the indictment or accusation is filed, or at the next succeeding regular court term thereafter, or by special
All right,
permission.
let me stop you and ask you to address the specific terms of
And
the statute. Let me finish. At what time, at which term, was either the accusation or indictment upon which you were charged filed?
That's immaterial, Your Honor.
No, it's a timeline. That's exactly what you just read to me.
Well, Your Honor, cut me off if I could continue.
All right, go ahead.
Okay. And served upon the prosecutor and upon the judge to whom the case is assigned, or if the case is not assigned, upon the chief judge of the court in which the case is pending. And that's what I did, because the state failed to assign a case. It was, and it says right here, a demand for speedy trial filed pursuant to this code section shall be filed as a separate, distinct, and individual document, and shall not be part of any other pleading or document. Such demand shall be clearly be titled demand for speedy trial. Reference this code section within the pleading and identify the indictment number or accusation number for which such demand is being made. The demand for speedy trial shall be binding only in the court in which the demand for speedy trial is filed, except where the case is transferred from one court to another without a request from the defendant. So, Your Honor, because I complied with 17-7-170A and B, and the state decided that they weren't going to file this case until April of 2015, when they could have filed the case either in the October term or the February term, in which juries were impaneled, and I could have had my speedy trial. That's what this code section states, that I am guaranteed an absolute discharge and acquittal.
All right.
And I can provide case law on that.
And Your Honor, the state's response would be that what he's filed could loosely be construed to be a constitutional speedy trial demand. However, he's asking that it be given the treatment of statutory speedy trial demand, which is demand does not meet those requirements on his part. On the other hand, Your Honor, again, the statute that he just read for you said 2 terms of court within a filing of an accusation. Your Honor, we filed that accusation in the February term of court in April of this year. This is the following term of court. We're ready for trial today. We're trying to give him his trial today. And Your Honor, again, this motion has already been heard and denied. He just admitted to the court that it had by Judge Booth.
Well, the problem I have with his side of the case is that there was actually no accusation in compliance with the statute or indictment prior to April 8th, 2015. That, as I recall, the terms of court are 6 months in Bear County, and this would have been in the first term on April the 8th. We're now into the second term, or the second 6-month term of court, and you basically would have until, even if you construed this demand as carrying over, you would have had the first term and the second term in which to try the case. Now, I honestly don't know the impact of a change in the and a refiling of the accusation. Obviously, the state can't use the refiling to extend the period of the speedy trial demand. But on the other hand, obviously I can't proceed with a new accusation until Mr. Cooley's had time to respond to that accusation. What's the state's response to the court's concern there? By modifying and refiling the accusation, have you extended the speedy trial period?
And Your Honor, I would not think so. I mean, it's the same case. The refiled accusation is based on the exact same charges, it's just worded slightly different. It's the same code section, the same acts. There's not an addition or subtraction of any charges. Your Honor, I think if there were a way to cheat on a speedy trial, somebody would have figured it out before now, and I don't think I found it today. I'm not asking for that, Your Honor. I mean, I understand that he is entitled to a continuance if he wishes. I don't think that would, Your Honor, correct me if I'm wrong, I don't think that would give him grounds to refile everything all over again and have it all heard all over again. And again, Your Honor, I believe this speedy trial demand's already been denied for being insufficient.
Well,
But Judge, if he wants to go on the next trial calendar, if he wants to go this week, we're ready to go. And that's what we're trying to do.
is there another trial calendar within this term of Bear Superior Court?
Well, Your Honor, there's another misdemeanor trial calendar in January, but I'd go ahead and put him on the next trial week if that's what you want.
Well, is there a next trial week within this term of Bear Superior Court,
Yes,
which
Your Honor.
is essentially before the end of the month of the year?
Judge, would you like me to read out what the remaining trial weeks are?
Well, no, here's what I'm going to do. Obviously, at this point in time, the demand for speedy trial is not right for consideration. Even if you consider his letter of August 15th to be relevant to the issue of speedy trial, we're still within the second term, even if this demand was pending at the time of the filing of the accusation. I'm going to order that he be arraigned and tried within this term of court.
Your Honor, if I may, I know the prosecutor informed you that the judge ruled on my demand for dismissal for lack of speedy trial. However, just giving an oral decision on that is in violation of Barker v. Wingo, in which there's 4 reasons that the trial court has to consider in accepting or denying a demand for a lack of a speedy trial. Judge Booth did not do that. He just gave an oral ruling denying it without even considering the 4 reasons in Barker v. Wingo, and that right there has been a basis for my appeal. And if Your Honor does not grant me this absolute discharge and acquittal, that's going to be another basis for an appeal, and to be rearranged. If I'm going to be rearranged, I'm guaranteed to be arraigned, have a motions hearing on my motions again. My motions can't be denied because they're rearranging me, and prior to a different arraignment, my motions were denied. And we have a calendar call, and if it reaches that far, a jury trial, and I'm still going to file all my motions again, which I'm absolutely guaranteed the right to do.
Well, I don't question that, and I'm absolutely amazed why, if it's not a substantive difference, does the state make it more complicated by amending the initial accusation, but
Judge, the state would, at this point, the state would be happy to withdraw the amended accusation if we can undo that. Your Honor, I did not anticipate that that would open up the Pandora's box that we have today. I was simply trying to tailor it closer to the statute to make sure that we had a fair trial today. And, Your Honor, I don't know. We're ready for trial whenever he wants one.
Your Honor, it has never been so far a fair and impartial trial for the defendant. That's all I have to say on that.
I don't know the answer to that, and that's not an issue before me, but the issue before me is whether or not under the current circumstances, that is, upon the filing of a amended accusation, your speedy trial demand that was in existence, according to your theory, at the time of the initial accusation, which was April of 2015, it's untimely because we're still in the second term of court, and there are more trial calendars to be brought forth during this existing term.
Well, actually, it's not untimely, Your Honor, because if my memory serves me correctly, I filed a demand for speedy trial prior to or at my hearing in municipal court, and on April 25th.
Let me resolve that issue very quickly.
And that carries over. That does not stop my demand for a speedy trial. I have case law on that, which I would submit to the court.
Well, I don't believe that you can go out and file a speedy trial demand on the day you're given a ticket in a municipality, which would then bind the subsequent court to the terms of speedy trial, and that's what you're...
Your Honor, I do have case law where the Georgia Supreme Court said that a demand for speedy trial takes effect when you file it. It could be on the same day that you are arrested.
Well,
I do have case law, and I'll submit that case law to Your Honor.
no, I don't want you to submit anything to me, because
Well,
I may or may not be the judge who's sitting on this trial when it comes to pass. I'm simply going to conditionally deny the dismissal on the demand for speedy trial at this point in time, simply because the second term of court has not expired from the time that you contend a speedy trial demand was filed. Now,
well, the second term of court would have been...
be the subject of your appeal if you elect to appeal. And I'll ask the law clerk to draw a simple order to that effect. Any other motions pending?
Well, the only other thing I have, Your Honor, is back on Tuesday when I was before Your Honor and I, case 636 was dismissed. It was dismissed pursuant to the charges for my pickup truck. Now, the charges that the state is trying to charge me on, we were supposed to be at trial today, also relates to my pickup truck. Now, I would contend, Your Honor, that because the state dismissed those charges against me for my pickup truck, and these are the same charges that were here today, this would be now considered double jeopardy, trying to charge me again on charges that have already been dismissed related to my pickup truck.
State's
Your Honor,
response.
Your Honor, he's referring to a completely different case. this is not double jeopardy, this is a completely different day of the offense, different incidents. That case was disposed of last week. I don't know what he's got going on with the city of Winder, Your Honor. The chief of police called me to ask about it the other day, said that his truck has never been held as evidence from him, that it's always been released to him, all he has to do is pay the tow and the storage fee.
Your Honor, if I have a case that's been dismissed, I am not responsible for paying anything.
Your Honor, that doesn't mean that.
Just because they told my
Alright,
truck, and I always made a
we're
claim that
not
my
going
truck was
to-
towed illegally.
We're
They
not
can't
going
force
to
me to
that.
pay towing fees.
Well,
That would be on
you-
the city of Winder, because they were the ones who towed it.
the only thing I said in response to your request that the truck be released when the null process was filed was that there would obviously be no longer any reason to hold or deny you access to your truck. The DA undertook, at the request of the court, to inquire as to whether there were any other reasons why your truck should be held. As I understand it, the DA gave the city of Winder a property evidence release that allowed the city to release any evidence that they held, including the truck. As I understand it, the city responded that they had never held your truck.
Well, actually, they did, Your
Don't
Honor. They
interrupt
were
me,
going-
Mr. Cooley, let me finish.
Okay,
The city's position was that you had simply refused or failed to proceed to gain custody of your truck from the get-go because they had instructed you personally that you could get your truck at any time. Now, I told you, and I'm going to tell you again, I am not getting into the dispute between you and the city of Winder over who owes what for record fees. This court has been assured that there is no claim against your truck by the city of Winder pursuant to these charges, that you have been free to obtain your truck at any time and that you knew it. Now, if that is not the case, then my suggestion is, and I told the city as well, inform the city attorney so that the city can decide whether or not there's a civil issue regarding the truck. We're through with that truck.
well, Your Honor, if the tow itself was illegal, and.
Well,
and-
that
and-
is a.
And the city is expecting me to pay now extortion fees, which is what it is. They tow my truck for no reason, and then you have to pay to get it. No, that isn't how our justice system works.
Well, at this stage, this court is not involved in that issue, so,
That's why I submitted an order for Your Honor to sign.
well, I didn't sign that order and I don't intend to.
I have on videotape the chief of police telling me when I served him with what I got from the prosecutor's office, he said, "This is not a signed order from a judge." He said, "I need a signed order from a judge." I have it on my camera right now.
Well, you don't have a signed order from this judge, because this judge never signed an order,
Well,
so
I understand that, and that's why I'm asking Your Honor to sign my order.
I'm not going to sign your order because obviously, the city was not present, the city was not able to present their position. The city's position apparently is that they've never held your truck under circumstances where you were not able to have obtained possession of it. Now,
Well, I was never given the opportunity, Your Honor, to
Okay.
prove that the tow itself was illegal.
okay,
They dismissed the charges, and I couldn't even prove, because I can prove before Your Honor now that the tow was illegal, but they're gonna claim that, well, the officer who had it towed doesn't work for the police department anymore, so we can't bring him into court. I mean, if I have to subpoena him, I'll subpoena him into court.
I think you obviously should. But that's not an issue that's before me, so I'm not concerned with it.
And Your Honor, he's asking for a civil remedy. If
This is
that's
not civil remedy. This was under a criminal case.
Well, if you're,
If Your Honor found me guilty, or I was found guilty, you're not gonna come to me and say, this fine that we're assessing is a civil one, so take us to civil court for me to pay. That's not how it goes. Nothing should be civil when it's in a criminal court.
yeah, that's a good theory, and I.
A civil remedy would be when I finally sue them for what they've been doing.
That's apparently where this is going, and I wish you well.
However, Your
But it's
Honor,
not gonna
to
be
this day, I
resolved.
still don't have my truck and all my property, and because it was an illegal tow, I'm demanding my property back
Well,
from the Weimar Police
the
Department
state
and
does
Brown's
not-
Record.
The state does not hold your property, and I'm told that you even have a civil action pending with the record company, and I'm certainly not assigned that case as well.
Well, they want to sell my truck, that's why there was a civil case pending.
Well, again, Mr. Cooley, the only thing I can say is that your motion for discharge under your existing speedy trial demand, if that is in fact what that is denied, we're still within the.
For the absolute
second
discharge
term.
and acquittal.
Right, so we're still within the second term of court.
And Judge, if I could just clarify, if I can withdraw that amended accusation, we'll go forward under the original one, Your Honor, today. If you want to have the trial today, if he's okay with having the trial today, I don't know if you can withdraw an amended accusation. but I would
Well,
love to.
we've dismissed the jury, as I understand it, based on the information provided to me earlier. So there is no jury by which we can try this case today.
I'm ready for trial. If they're not ready for trial, I demand this case to be dismissed.
Judge, I'm ready for trial. I want to have a trial this week, if we can have one. I mean, has the jury been dismissed for the whole week, or? just
That
for
was
today?
my understanding. The court will be in recess for 10 minutes while I find out what the status of the jury is. Has the jury gone home? Do y'all know?
Yes, sir. Your Honor.
All right,
May I approach?
you may. You tonight. Okay. It's my understanding that the jury has not been unconditionally released, that they're to call back Tuesday evening, which would mean that there would be a panel available Wednesday by which this case could be tried. Now, is that what the state wishes to do?
Yes, Your Honor. If we
Is
can-
that what Mr. Cooley
I would
wishes
object to
do?
that, Your Honor. I was prepared for trial today. This was the date for trial. The state decided to flip-flop on things. They wanted a new indictment, a new accusation. Now they're changing their mind. I demand this case be dismissed, Your Honor.
Judge, he's not, none of these motions are applicable within the law, Your Honor. He's got a trial week set for this week, and we're
Well,
ready for trial.
I'm going to, as far as I'm concerned, the fact that the state called the case for Monday and it's going to be actually presented for trial on Wednesday is not a ground for dismissal or anything else. I'm not going to respond to the state's request to withdraw their amended accusation. I think the state needs to look into what they've already done and decide whether they can reverse it. I don't know the answer to that. You have filed an amended accusation. But this case is going to be heard in this courtroom on Wednesday morning, and we're going to instruct the clerk to have a panel of jurors here from which we can select a jury.
if that's Your Honor's decision, I demand that I be rearraigned on the new accusation
Well,
as
I
is
think
guaranteed me by the Georgia State Constitution, and we go through the entire process of me getting a notice of arraignment, being arraigned, me being able to file all my motions again, have a motions hearing, well into next year. And this is no fault of my own. This is the
Well,
this is the
you may
prosecutor's
be
fault.
right in that regard, but I'll.
However, Your Honor is penalizing the defendant.
Well, whether or not the state can file and then withdraw an amended accusation is a problem the state needs to address, but I'm simply stating that the trial will be called on Wednesday morning. I'm going to instruct the clerk to have us sufficient jurors to seat a panel, and if there are appeals that to be taken in any regard to that, you can certainly do so.
I would demand a motions hearing to see, so I can research case law to see what the state has done to this case is even legal.
Okay. I never prohibit anyone from filing appropriate motions, so
And I don't believe I can file a motion by Wednesday.
well, whether
And
you're
and
required
that,
to
and
file a
that would just,
motion by
that would just
Wednesday,
prejudice me if Your Honor
or whether you're,
continues with this case to Wednesday and I don't have the opportunity to properly respond.
okay, that may be the case if they can't withdraw their amended accusation. We'll find out. See you all Wednesday morning at 9 a.m.
Thank you, Your Honor.